As a business owner, here's what you need to know about commercial leases. Hi, I'm Caitlin Bowman and I'm a senior lawyer in our business and property team here at Turnbull Hill Lawyers. Today, I'm going to guide you through commercial lease agreements in New South Wales. As a business owner, signing a lease is a big decision and can be one of the first large financial transactions you enter into. Given this, you should do proper due diligence and seek advice into both the premises and the terms and conditions of the lease. It's important to ensure that the commercial lease reflects the agreement between you and the landlord and your legal requirements. Keep in mind that these requirements are different in each state. Firstly, let's talk about what a commercial lease agreement actually is. A commercial lease agreement is a document which grants you an exclusive right to use the premises, sets out the terms of the lease, and the rights and responsibilities of both the lessor, known as the landlord, and the lessee, you as the tenant. It typically deals with the length of the lease, options to extend, the amount of rent payable and how this is increased, if the lessee is responsible for outgoings, for example, council rates, and what you're permitted to use the premises for. If you're planning to lease a retail premises, it's important to know that there is specific legislation that applies. In New South Wales, it's the Retail Leases Act, and there is various other legislation across the states and territories that is also retail lease specific. A retail lease is usually when you have a shop in either a shopping centre or retail area, although it can exist outside of these, and is wholly or predominantly used for selling goods and services to the public. The Retail Leases Act was enacted primarily to protect tenants when entering into lease agreements, as most retail lease premises are in larger shopping centres where the lessor holds the bargaining power. For example, if you were to lease a shop in a Westfield or other large commercial building, the legislation requires your landlord to provide you with a higher degree of disclosure of terms prior to entering into the lease, and it also deals with mechanisms to resolve disputes. Prior to entering into a lease and during negotiations to lease a premises, there's a number of things that you should consider. The duration of the lease, how much the rent is, when the rent will be reviewed, your outgoings, what you can use the space for. For example, if you're a hairdresser, you'd want to have something like hairdresser and sale of related products. Who's responsible for maintenance and repairs of both the premises and the fixtures? And what indemnities and liabilities are applicable regarding any type of injury or damage to building, and who's going to pay for those. An important part of a commercial lease agreement is detailing the outgoings. Outgoings are expenses related to the premises that you agree to pay in addition to the rent. The lease and the landlord's disclosure statement, if it's a retail lease, must clearly specify the outgoings that you have to pay. And outgoings are usually a major cost for the tenant. Some of the usual outgoings are local council rates and charges, water, sewage and drainage charges, land tax, insurances, strata or community levies, and potentially management fees if there's a managing agent appointed. There's many other types of outgoings that may be included in a lease, and each should be identified at the negotiation stage of the lease and an estimate provided so the cost is disclosed and understood by both parties. A common question that I get from commercial tenants is, can I terminate a lease early? So whilst you should always ensure that you're able to see out the full term of the lease from commencement, there can be many reasons as to why you would want to terminate a lease early. For instance, your business is unprofitable, or you've realised that you need a different or a bigger location. Whatever the reasons, breaking lease obligations is usually considered a breach, and the landlord may be entitled to recover damages, including all unpaid rent and expenses for the rest of the lease term. Whilst not ideal, there can be a number of ways that a lease can be terminated early by you as the tenant. One, the first option is to assign, sublease, or transfer the lease. And this requires that you or the landlord find and locate a new tenant. It may be looking for someone to take over the premises, or you might want to sell the entire business together with the lease. You may require the landlord's consent to assign, sublease, or transfer the lease, and this is usually found in your lease or the relevant legislation. Alternatively, you can surrender the lease. Most leases may not contain a specific surrender clause. The landlord may, at their discretion, consent to you surrendering the lease, usually on satisfying certain conditions. For example, they may require you to pay out a certain portion of the remaining term's rent. On the flip side, when you enter into your lease, it's important to know if the landlord can refuse to renew your lease. So if the lease does not contain an option period and the term of the lease is coming up for expiry, the landlord can refuse to provide a new lease. However, if there is an option and you exercise your option correctly, then the landlord must provide you with a lease on the same terms for the option period and with the rent adjusted in accordance with the rent increase mechanism. There is no legal requirement for a landlord to renew a lease. However, most leases give the tenant an opportunity to hold over the lease and stay in the shop on a month-to-month basis at the end of a fixed term, with either the landlord or tenant able to give 1 month's notice to terminate the lease. If you're already in a lease and there's a potential dispute with your landlord, there's generally a few steps to follow. First step, read the terms of your lease carefully. Often there will be a dispute resolution clause which will outline the steps you and the landlord should or must take to attempt to resolve the dispute. Usually there'll be an informal discussion with the landlord where you both try to reach an agreement. If you can't reach an agreement following the dispute resolution procedure set out in your lease, you will need to follow the formal processes set out in the legislation, which applies in the relevant state or territory. If the lease is a retail lease, the Retail Leases Act will apply, and it has mechanisms and processes for resolving a dispute as follows. 1, both parties must attempt mediation with the New South Wales Small Business Commissioner before applying to New South Wales Civil and Administrative Tribunal, known as NCAT. However, there are exceptions to that. 2, if mediation is unsuccessful, both parties will receive a certificate from the Commissioner, which must then be attached to the application to NCAT if the parties want to progress the dispute. A lease is a binding agreement, and failure to comply with the terms of the lease could have significant consequences and financial costs. As I said earlier, it's a big decision and probably the first large business transaction that you're going to enter into. So it's important to seek legal advice prior to entering into your lease. A lawyer knowledgeable in commercial leasing can provide you with advice on the terms of your lease and also advise you on which clauses or items you should negotiate or even remove from your lease. If you require legal advice about a lease you're about to sign or one that you already have, please feel free to contact our business team here at Turnbull Hill Lawyers.